This meeting of the House Regulatory Reform Committee to order. My name is Dennis Trudell. I'm the presiding chair for this meeting. Please, Representative Ward, you have the floor.
Thank you, Mr. Chairman. Good afternoon, everyone. I'm bringing this bill before the floor, the PCS specifically, in reference to rental inspections. The genesis of this bill basically occurred when I was approached by my municipality stating that they had issues with the General Statute 160A-193 not allowing them to have any punitive measures for violations of basic housing limits. And I spoke specifically with them, got their concerns, contacted bill drafting. They informed me I was going to run it as a local bill, but they told me that because it dealt with health and sanitation, it could not be run as a local bill, had to be run as a public bill. And then we ran that bill. We had an initial hearing, presentation before the local committee, and it passed through there. After that period, I had some conversations with representatives from the Realtors Association, which we talked about things, and I received some language from them. I incorporated a portion of that language into this House PCS, and thinking we had a concession between us all, I found out very recently that we do not. For transparency, the Realtors Association is opposed to this bill, as is the Apartment Association. To get into the specifics of the bill, this bill allows the inspection department to make periodic inspections only when there's reasonable cause to believe that unsafe, unsanitary, or otherwise hazardous or unlawful conditions may exist in the residential building or structure. And reasonable cause means any of the following: landlord or owner has a history of more than 2 verified violations of housing ordinances or codes within a 12-month period for which the local government can take action under General Statute 160A-193. 2, there has been a complaint that substandard conditions exist within the building and there's been a request that the building be inspected. 3, the inspection department has actual knowledge of an unsafe condition within the building or violations of the local ordinances or codes are visible from the outside of the property. The bill goes on to state that in the event that there's found to be a violation, that a legislative hearing regarding the plan and establish a plan to address the ability of low-income residential property owners to comply with the minimum housing standards. But in no event may a local government do any of the following: adopt or enforce any ordinance that require any owner or manager of rental property to obtain any permit or permission under Article 11 or Article 12 of this chapter from the local government to lease or rent residential real property or to register rental property with the local government, except for those individual properties that have more than 4 verifiable violations in a rolling 12-month period, or 3 or more verified violations in a rolling 30-day period, or upon the property being identified within the top 10% of properties with crime or disorder problems. The bill would require that an owner or manager of residential property enroll or participate in any government, it would not require that an owner or manager of residential rental property enroll or participate in any government program as a condition of obtaining a certificate of occupancy, and would not levy a special fee or tax on residential rental property that is not levied against other commercial or residential properties. But unless expressly authorized by general law or only applicable only to an individual rental unit or property described in the clause 1 of this subsection, the fee does not exceed the amount set forth in a subsection F of this section in any 12-month period in which a unit or property is found to have verified violations. Now, verified violations has several meanings. That's an aggregate of all violations of housing ordinance or codes found in individual renting units or residential real property within a 72-hour period. violations that have not been corrected by the owner or manager within 21 days of receipt of written notice from the local government. Should the same violation occur within more than 2 times within a 6-month period, the owner or manager may not have the option of correcting the violation. If the housing code provides that any form of the prohibited tenant behavior constitutes a violation by the owner or manager of the rental property, it shall be deemed a correction of the tenant-related violations if the owner or manager within 30 days of receipt of a written notice brings a summary ejectment action for the tenant evicted. So basically it would purge the owner of that offense. Section F of this bill says that local government may levy a fee for residential rental property registration for those rental units which have been found with 3 verified violations or housing ordinances or codes within the previous 12 months, 2 of the same violations within the previous 6 months, or upon the property being identified within the top 10% of properties with crime or disorder problems as set forth in the local ordinance. The amount of that fee, the amount of the fee shall cover the cost of operating the registration program and shall not be used to supplement the revenue in any other areas, and should not exceed 30% of the total rent collected on the property during the period in which the verified violations occurred on the property. Basically, what this bill is doing is saying there shall be no inspection or fees or permitting fees for rental property, but it gives teeth to the 160A statute and holds landlords accountable for minimum housing standards and provides relief for our most marginalized residents. I'm a staunch conservative, and I disdain government overreach into personal lives. But this is not about a conservative issue. It's not about a liberal issue. This is about doing what's right for our citizens. And I'll stand for any questions.
Hey, questions or comments from committee members? Chairman Zenger.
Thank you. A couple of questions and maybe a point. One, it talks about a spot in here, someone just registers a complaint, then that triggers an inspection. And I wonder if it's, a charge in search of a crime. In other words, if somebody's disgruntled, they can just start picking up the phone and making complaints, and it can go. So that's the first point. The second point, and I want to get you an opportunity to explain this, but the second point is it seems like in Section D that it actually kind of puts the landlord in a position of law enforcement, and that they're supposed to find bad, if there's people that are breaking laws and that kind of stuff, that they're supposed to be the ones, involved in trying to fix that. And so, there's a lot of issues that go on in low-income housing. And I'm not advocating for landlords to have substandard housing, but I just know that it's difficult to evict people. It's difficult. There's a lot of difficulties that also, as crazy as this sounds, those low-income things provide housing for a certain segment of the population as well. So there's a whole lot of tension here moving around. And so those are the two things that I saw right out of the gate that I was a little concerned about, is putting them in a position of law enforcement and also setting up a situation where frivolous complaints can be thrown to essentially harass back at the landlords.
Representative Ward.
Thank you, Jack, for the question or for the comment. I think that your concerns are valid. The fact that there could be frivolous complaints is something we have to deal with in everything we contend with. That is the purpose for the inspection, to determine if these are frivolous complaints. This bill does not address any frivolous complaints that come out of a tenant or for their for alleged violations. But under the statute, under Section D, it actually does not throw the landlord into the position of law enforcement. He actually it does address what's in 160A, which this is taken directly from 160A. 193, and basically it tells that the law enforcement should be involved, and in the event that law enforcement is not involved, then the landlord may be required to address any criminal activity, which may include testifying in court in a summary ejectment action or other matter to aid in evicting the tenant.
Representative Zenger, follow-up?
Yes, sir. So in Section D, it says, the local government shall notify landlord of any crimes, disorders, or other violations that will be counted against the property to allow the landlord the opportunity to attempt to correct the problems. But it talks up there that right above that, it says that the property is identified to be in an area within the top 10% of crime and disorder problems. So that to me makes it sound like, you know, if you've got, let's suppose you've got tenants that decide every night there needs to be an outdoor party kind of there, that now the landlord is responsible for making sure that there's no outdoor party there every night that's disorderly and having to shoo everybody away. That really seems to be more of a responsibility of law enforcement, I would think. But
I would concur with you.
Representative Ward?
I'm sorry. I would concur with you in that fact, but we all know that law enforcement can't be everywhere all the time. And we know that things occur outside the purview of law enforcement, and we realize that landlords who own property, who monitor their property and take care of it properly, are aware of what's going on their properties. And should there be violations, then that would behoove them to have a vested interest in their property and report it to law enforcement so it can be investigated as a criminal conduct.
Representative Zenger?
just a suggestion, and I wonder if it would be worth taking a look at the laws of eviction and see if there's if there's something we can do to make it easier to get rid. You know how they say one bad apple spoils the whole barrel.
Yes.
Make it easier to get rid of and have a way to identify bad tenants and make it easier for the landlord to be able to get them gone, because it can take months and months and months to evict somebody, and the whole time, if they're under eviction, you know, the old saying, it's a rental, don't be gentle, you know, it kind of goes from there. So just a suggestion, it might be something we want to look at to see if there's a way to do that.
Representative Ward?
Excuse me. I agree with you that there should be some way to tighten up the eviction rules, but that's something that will fall upon us as a legislator, not as upon the legislature, not upon the actual entities that be in the municipal and local government.
It's a rental, don't be gentle. That's very clever. Representative Butler?
Thank you, Mr. Chairman. So I had a couple of questions. You've put forward some examples of what look to be very horrific, unsafe, and unsanitary conditions, and I don't think anybody here would disagree with you that if that is a pervasive problem, then a landlord needs to be held accountable. But I have a concern, and I wonder if the bill does this, and maybe it does. Does it differentiate between those things that are minor in nature as opposed to those things that are truly unsafe and unsanitary? What I mean by that is, being a landlord, I get these citations or notifications with regularity saying that my grass is too tall. Well, I've told the tenants it's part of their lease, it's part of their responsibility, and we've had torrential rain, and by God, the grass grows pretty fast. So, I don't want to get on a list that requires me to seek authority from my local government because my grass was too tall and the tenant failed to cut it. I mean, is there a differentiation between problems like that and these really horrific mold and sewage problems that we see reflected here?
Representative Ward?
Thank you. Very good question. Thank you. I am a landlord myself. I own rental property within my local jurisdiction or local residential area. This bill does not differentiate specifically to that, but normally the grass issues such as that fall under your local ordinances for code enforcement. Mm-hmm. And I've received the same thing. Your grass is too tall, then you have to contact your renter and say, look, you got to cut the grass. It's like
Yeah.
And
And a
but
quick
it does
follow-up,
not-
Mr.
It does not specifically differentiate in that.
Follow-up, Representative Butler?
Yes, sir. Well, I thank you for that, and I do think we need to somehow make that differentiation because there are things that happen at rental properties sometimes that are minor in nature, that are not, a safety or a health issue, and I'd hate to see all sorts of landlords get caught in a dragnet because of peeling paint, for example, or tall grass or things that are minor in nature. And then secondly, my concern here is I'm not exactly sure what a disorder problem is, but as Chairman Zinger said, people got to behave right in those properties. And just because, you can't tamp out bad behavior just by your best efforts sometimes as a landlord. You can try and you can follow the process, but it doesn't always work. And so if someone, and I know it's hard to capture the element of good faith, too. If a landlord is informed of a problem and uses their best efforts and they don't bear fruit, but is operating in good faith, it's not fair for them to be caught up in that process unnecessarily. So I think the bill is good in many respects because we certainly don't want to see these horrific conditions. That is, I'm with you 100% on that. But if it's tall grass or it's peeling paint or it's somebody who gets drunk every Saturday night and shows out on the front lawn, those are different things, and I don't think that's a landlord's, responsibility necessarily, particularly if they're operating in good faith. So let's keep working on it is what I would say.
I'm sorry.
Representative Ward?
I would be glad to speak with you after this about some of your ideas that we may be able to incorporate in this bill as it goes forward.